Para. The respondent number 1 admitted that he had engaged Ismail as a driver. He, however, denied paying rupees 3000 per month and daily bhatta rupees 50 to deceased Ismail and contended that deceased was paid salary of rupees 900 per month. Respondent number 1 also did not dispute that Ismail had died as a result of the injuries sustained in the course of the employment. Respondent number 1 claimed that the vehicle was duly insured and hence respondent number 2 is liable to pay compensation to the applicants. Para. Respondent number 2 contested the claim by filing written statement at Exhibit 22, thereby denying the contents of the application. It is contended that the deceased was never employed by respondent number 1 and was not holding a valid driving license for driving said tractor. This respondent disputed its liability to identify the respondent number 1 insured for breach of terms and conditions for insurance policy. Learned Commissioner framed issue-wide Exhibit 23 and recorded evidence laid before it by the impugned judgment and award. The application came to be allowed, with direction to respondent number 1 and 2 to jointly and severally pay compensation of rupees 3 lakh to the applicants along with the interest at the rate of 12% per annum from the date of filing of the application till realization of the entire amount. While arriving at the said finding, it is held that both the sides have failed to place on record driving license of the deceased, and hence an inference was drawn that the deceased was holding a driving license on the date of the accident. As far as amount of compensation is concerned, evidence of applicants about deceased Ismail receiving wages of rupees 3000 per month came to be accepted as there was no rebuttal to the said evidence from respondents. Thus, with this finding, the Learned Commissioner had granted compensation to the applicants along with interest. Present appeal is filed by respondent number 2, insurance company, predominatingly on two grounds, that is, breach of condition of the policy, as deceased was not holding valid driving license for driving the tractor, and that the Learned Commissioner had committed error in considering the amended provisions of the Act for the purpose of grant of compensation by applying the same retrospectively. Para. Learned Counsel for the applicant, original respondent number 2, submitted that since the burden was on the applicants to prove that deceased was holding valid driving license to drive the tractor, in absence of any evidence being adduced, the Learned Commissioner is not justified in recording finding that there is a presumption about driving license being held by the deceased at the relevant time. He further argued that relevant time, by virtue of explanation of Section 4 of the Act, the maximum amount of wages which could have been taken into consideration by the Commissioner for computation of compensation was rupees 2000 per month and not rupees 4000 per month, increased by virtue of Amendment Act 46/2000, dated 8th December 2000. According to him, it was not open for the Commissioner to consider the said amount as the amended provisions would have applied prospectively and it cannot relate back to the date of accident. Para. Learned Counsel for original claimants, respondent number 1 and 2, herein submitted that by leading cogent evidence, the applicants have proved that the deceased was drawing rupees 3000 per month as salary, and hence no error is committed by the Learned Commissioner by computing amount of compensation on the basis of the said amount, he also sought to applicants ought to have been from the date of accident and not from the date of filing of the petition, as is done by passing the impugned judgment. Present appeal is filed under Section 30 of the Workmen's Compensation Act 1923, which provides for an appeal to this court from the order of the Commissioner of awarding compensation, interest or penalty, or order refusing to allow redemption of half monthly payment, etc. First proviso to Section 30 of the Act states that no appeal shall lie against any order unless a substantial question of law is evolved in the appeal, and in the case of an order other than an order such as is referred to in clause B, unless the amount in dispute in the appeal is not less than 300 rupees. Para. The aforesaid provision makes it manifestly clear that in the case of challenge to grant of compensation, an appeal can be entertained only when there involve a substantial question of law. Thus, for entertaining an appeal under Section 30 of the Act, appellate court must satisfy itself about existence of an substantive question of law. Therein, at this stage, it would be fruitful to refer to judgment of the Honorable Apex Court, wherein what is substantial question of law has been laid down. Stop.